SCC Times presents to you these special conversations that throw a light on critical issues concerning law and policy. Today we talk about the scope and scope of arbitration in India. India aspires to be a $5 trillion economy by 2027. That also puts us in a position where we'll have complex commercial disputes. And of course, arbitration is one of the most efficient and effective methods to deal with such kind of disputes. But are we really ready to be the next arbitration hub? We have with us experts who will throw more light on the subject. We have Justice Hemant Gupta, who is the former judge of Supreme Court of India, Chairperson of the India International Arbitration Centre. We have Mr. Kunal Vajani, Joint Managing Partner of Fox & Mandal, former court member at the ICC, International Court of Arbitration. He is a leading dispute resolution practitioner. Justice Gupta, I want to start with you. I spoke about the topic that India aspires to be the arbitration hub in the world. Are we really headed in that direction? And if not, what are the impediments before us?
India is like an elephant, is a slow mover. We should have taken this initiative when the economy was liberalized in 1991. At that time, we carried out different reforms, but not in the field of dispute resolution. So, but nevertheless, we are late, but we are still on the path. We'll surely achieve the target with the cooperation of all of our friends, the lawyers, even litigating parties, to achieve the ultimate goal of India as a hub of international arbitration. The role of the courts is also very important. Some courts are very active, like I would say Delhi High Court, where the commercial courts are given, I would say, better determination or better level as compared to some of the other high courts. So we need to have active high courts in dealing with the commercial arbitration, because the objections are to be decided by courts, the enforcement of the award is by the courts. So that's one field where we need to work on.
Mr. Vajani, opening comments from you. As a lawyer, what do you think? What are the challenges you encounter?
Before going to the challenge, let me tell you what we need is a mindset change.
Right.
We started with the whole concept of arbitration being part of what is called as an alternative dispute resolution mechanism. Evolving from 1940 as a statutory regime to a 1996 statutory regime, and the need of the hour alternative dispute resolution regime, arbitration has emerged to not be any alternative but be an additional. So that A in the ADR for me changes to be an additional dispute resolution mechanism. It is quintessential, it is part of the method in which we will resolve disputes within the framework of best global practices and the statutory framework as mandated by our legislative policy makers.
Okay.
If you ask me about the word hub, it has been over a decade that I have maintained a very simple answer to this, that hub can never be the aspiration. Ecosystem is the aspiration. We have to create an arbitration ecosystem which actually emulates the best practices from every successful jurisdiction which has been able to bring about a systemic legislative and cultural change in resolving disputes by using arbitration.
Okay. To add to the point and take it forward, you said this is an additional dispute resolution mechanism. That's one positive way to look at it. And if I were to look at it critically, On many occasions, it has been criticized the intervention of courts in India is too much. There are multiple levels and layers at which an arbitration tribunal order can be challenged. And that deters the finality of the outcome of such a process like arbitration. Is that the reason why you say it's additional?
Not really. I think I put it as an additional regime because I see it as a source.
Okay.
The original proceedings emanate out of arbitration. The last bit that you mentioned is intervention of courts. To my mind, is what I would categorize as an easy topic when you want to take the course of India bashing.
Yeah.
We have to emerge out of India bashing. The word and the thought processes of public policy that we put down as a narrower position to avoid intervention of court, I think has had its own landscape. Justice Gupta has been party to several of those decisions where he has had to mold relief on interpreting that word public policy. It's not an unruly horse as one would put down for it to be. And that evolution of intervention has now been very calibrated and very graded. Self-restraint is, in your thought process, the most difficult position.
Yeah.
You are a judge, there's a matter before you, and now you've been told maintain self-restraint. Why? Because it is arbitration. Oh, if it was a decree of a lower judiciary, I can intervene on it fully, but I'll let the injustice pass because it's come through an arbitral award? No. And that affects the conscience of our judiciary. We have a very conscientious judiciary.
Okay.
So it is not an unwarranted intervention. It is also somewhere balancing the rights of the parties involved in those matters and an inherent part of our system, which is reflected in the amendments which have come down from 2015 onwards, is to avoid any sort of unwarranted element in our awards, which is fraud, corruption. It is checked by this judicial intervention process in some form or the other.
Justice Gupta, you agree. I mean, you have been at the Supreme Court of India at the helm of many disputes. What kind of restraint do judges really have to exercise? Kunal mentioned a fantastic point that if it's the decree of a lower court, the judge is in a position to just correct the problem or, do away with the injustice that has happened. But if it's an arbitral tribunal order, there's a lot of restraint that needs to be exercised.
No, there is a fundamental difference. Like when the dispute regarding arbitral award comes into the picture, it is not a jurisdiction of that of a appellate court. It's supervisory jurisdiction. But ultimately, even in supervisory jurisdiction, the ground of attack of arbitration award under the law is, one of the grounds is against the fundamental policy of public policy of India. How do you define what is public policy of India? Then the judgment came to say that fundamental policy of public policy of India means if it is patent illegal. How do you define patent illegality? Patent illegality is also required you have to satisfy the conscience of the court that the award is primarily all right. Some mistakes here and there, it can be overlooked. But it's a subjective satisfaction of the court. What is patent illegality? What is not a patent illegality? You can't find four corners of a patent illegality. I give example generally. In second appeal, when the matter comes from the civil court, the High Court exercises a second appeal jurisdiction on a substantial question of law. What is substantial question of law? It's very difficult to define what is substantial question of law. Ultimately, it also boils down to the satisfaction of the court. When the court finds that there is something which is really amiss, the court will interfere, then it will become a substantial question of law. Otherwise, they say it's no substantial question of law. The conscience of the court you have to prick to succeed either against the arbitral award or against even the civil court decree. That is the crux of the matter. The words are play of, can be played. The judges will play according to the facts of the particular case.
Before I move to talking about the proposed arbitration amendments, I want to pick up from one point that Kunal mentioned about creating an ecosystem. Hub or no hub, there has to be an ecosystem around it. So compared to a London or a Singapore, these are great examples to look at. We can always aspire to emulate best practices from these jurisdictions. But what makes them more attractive compared to India?
No, basically I say that we don't have to emulate Singapore or Hong Kong or London. We have to develop our own ecosystem. Indian litigation operates in a different field than of London or other countries. We have to keep in mind what is the requirement of Indian ecosystem. Therefore, one of the good proposal in the arbitration bill is of creating arbitral appellate tribunals.
Yes.
So if that is there, it will promote two things. One is judicial arbitration. The second is that Section 34 is taken care of. So although the High Court will still have jurisdiction under Article 227 of supervisory jurisdiction, because that is basic structure of the Constitution, and that of the Supreme Court under 136. But one level scrutiny within the system will be better than as the jurisdiction of the courts, because India is a vast country. Sometimes we take Delhi as the India.
True.
No, but down south, I think Tamil Nadu will still be better, but other states are. I give you example. When I was in Bihar in 2016, the commercial court has come into existence at that point of time. The Commercial Court Act stipulated that you have to have commercial courts. So we got the data. There was no commercial litigation. So to nominate one commercial court, we nominated Principal District Judge of Patna as the commercial court. No, we can't compare one state with that of Delhi. Delhi has a different.
True, sir.
But the Delhi media, Delhi lawyers, they think that whatever happens in Delhi is bound to be good for the country.
Is that true, Kunal? Is that the perspective?
Really. Not really. And I can easily get out of this, because I am originally from Mumbai, migrated to Delhi over a decade ago. But what I agree with what Justice Gupta laid down is that the demography of our nation is such that we have to not be worried about emulating something, as long as we are conscious enough that the best practices are the paths that we are adopting, and then there is no rat race. We have to keep things going in the right direction and taking steps forward. Various transformative thought processes in the nature of an arbitration council or an arbitral appellate tribunal were mooted, deliberated, and brought about. Implemented, not implemented is going to be in a phased manner. But there is obviously, as you can see, a willingness to go towards creating that ecosystem in the right direction.
Yeah.
One thing in this ecosystem which is not being seen as a clear understanding from the other jurisdictions that you compared, and as Justice Gupta rightly said, that you put down comparison to states which are city states. That's a sovereign by itself. Hong Kong or Singapore is one city state.
Yeah.
India is a huge nation.
Yeah.
But in India, we have only one institution which we have been able to bring by way of a statute. Justice Gupta fortunately happens to be the person who laid foundation and has started building that institution. But what I think is missing in this ecosystem building is a clear understanding and recognition that this is our permanent institution. We are fragmented in a manner in which we conduct our institutional arbitral process.
Okay, I want you to hold that thought because it's something very important you're saying. So, is this fragmentation something that you've also experienced? You have a vast body of experience.
Yes, the way India thinks
Yeah.
is not uniform.
Yeah.
From Kashmir to Kanyakumari, not only the language changes, the thought process also changes. The litigation also changes. Nature of litigation also changes. So that there can't be one size fits all. That is can't be there. We have to think of overall umbrella that how the system will work. I would say that like thought of Arbitration Council of India is unique to India. No other country has something similar. So if Arbitration Council of India can be thought of by the Indian Parliament, that was a great step to regulate arbitration ecosystem. As of now, there will be no data that how many arbitrators get their award and how many awards are challenged before the court. Now we have National Judicial Grid, data judicial grid. In under arbitration, you will find some cases, but that is a broad division.
Yes.
Section 11 is also arbitration, Section 34 is also arbitration. That how many objections are being considered by the court is not there. So we need to develop an ecosystem where we can find out that how much is the problem of appointment of an arbitrator under Section 11, how many cases are before the court under Section 34, before the principal court, before the high court. Only 4 states in the country have the original jurisdiction.
Yes. Yes.
So, but meaning thereby that 23 other high courts don't have the original jurisdiction.
That's true.
Whichever ecosystem in arbitration has become strong worldwide, institutions have played a major role in it, in strengthening that arbitration ecosystem. As Justice Gupta pointed out, there's been a start in India, but most of the arbitrations are still ad hoc in the country. Why do you think as a litigator, as a lawyer, that is the trend in this country? Is it the lack of institutions?
It is not the lack of institutions that is the primary reason. It is the tertiary reason. The largest problem is the misnomer of cost effectiveness.
Okay.
Second problem with it is that you want to take this whole system out from being monitored in the right direction. So an abuse of party autonomy in some form also leads it to be an ad hoc position. India has various successful examples of international institutions and domestic institutions. Okay, I was part of an international institution. When I took charge as a court member, the data that was put in front of me, you would not imagine the number of government agencies, authorities who have used ICC as their dispute resolution clause.
Yeah.
And that is ICC seated in Paris at that point of time. The clauses of 80s and 90s and the early 1900s were seeing the day of light of disputes in 2000s. Huge contracts, huge obligations, huge stakes involved. You had to go through that route of dispute resolution mechanism. Indian institutions parallelly started developing. The court annexed institutions started blossoming. And they're functioning very well. So the faith system is only because of some misnomer or fear that has been put in to say that if you go the institutional route, it will not be cost effective. That is again, as I started with, a need of the hour in terms of a mindset change. That culture needs to change. But I have a reservation here, and with due respect to Justice Gupta, I have been maintaining this as a person whose real passion drives in arbitrations, domestically or internationally, is that the support that these singular institutions, which are city-state driven nations, are given, is not given to the institution which our nation has given birth to.
For example?
Our institution, which is IIAC, India has not taken any steps to promote it as its sole premier institution globally.
Okay.
Singapore minister is going to arrive at the end of this month for SIAC's arbitral symposium in India.
It's very difficult to segregate the government from that particular institution.
And
in the optics of
it is.
Yeah.
And that is the support a institution is required part of this ecosystem. Grading an institution, giving it marks up and down is going to only create multiple choices. You have got, prior to the IIAC's birth, MCIA, a successful chapter written for over 10 years. And why not? But if we don't want a nation to have one institution, at least we must accredit our institutions faster and promote them, and that effort is not forthcoming from either the state government or from the government of India.
Justice Gupta, your thoughts on this?
No, I agree with Kunal that the biggest problem is mindset. I will take his argument a little further. 1940 Act also talked about ad hoc arbitration. The court was appointing ad hoc arbitrator. And that same process continued in 1996 Act also. So we have grown with this system of ad hoc arbitration. 80 years, more than 80 years, we have been dealing with ad hoc arbitration. And I would even go to say, in Konkan Railway, the Constitutional Bench of the Supreme Court said that appointment of an arbitrator is an administrative power. But soon after, in State Bank of Patiala versus Patel Engineering, they says no, it's a quasi-judicial power. They have a very interesting paragraph. We say the institution is mentioned in 11.6 from the very beginning, that the court can, or Chief Justice can designate an institution as also authorized to appoint an arbitrator. What the court has said is that since it's a constitutional power, we can't allow the institution to delegate to decide this question of quasi-judicial power. Meaning thereby that institution will only recommend name, will appoint. No, it actually create a parallel system. Like institution, when we exercise the power of appointment of an arbitrator, it's not a quasi-judicial. It is the administrative
power.
So it should have been administrative power, simpliciter. It becomes easier. But because of the fact that it's a quasi-judicial power, and the court says that certain prerequisites are to be satisfied, that leads to the decision making. And 11.6, some judgments are long, even 100 pages judgments. So 100 pages, if you write for appointment of an arbitrator, is not a very conducive way. So mindset has to change. Mindset has to change from all angles. There is amendment consequent to the judgment in 2015 probably, where this it has been said, probably 11 section 3b or some 3a, that when the institution is appointing an arbitrator, is not exercising judicial powers. In a way, to take away the judgment in Patel engineering. But the fact is that the mindset has not been changed. We need to change our mindset. I have tried my best, but some effect may be there,
Definitely,
but
sir. Every effort, your efforts do count. But I take that point forward in talking about the proposed changes to the Arbitration Act. The mindset and ecosystem, two things that, gentlemen, you've pointed out. When we talk about setting up an appellate tribunal within the arbitration ecosystem, are we adding an extra layer which deters the finality of the award, which is impeding the finality of the award, or we are speeding up the process? How do you see it as a
There are two parts to this. I'll start with the positive one first. The positive in this is that you are taking out the already available recourse under section 34 from an overburdened conventional court system into the hands of a specialized arbitral tribunal, appellate tribunal. So that's the positive, and therefore it may become faster, it may become more accessible, it may become even much more focused, and there will be some certainty that you probably will be able to bring about within that system. The negative that I see is creation of one more tribunal, and you don't know who's going to be appointed on that.
yeah.
So if it is the right person in the right place, the actual noble thought process or the goals which are sought to be achieved will be achieved in the positives.
Is this a practice in any other jurisdiction? In your knowledge and understanding?
There is none of this kind.
I'm not very sure.
Yeah.
There is none.
But cutting short what Kunal is saying, that we don't know who will man the tribunals. The provision has to come into existence. You have to test it. I thought of it. Say if there is a 3-member tribunals award which is subject matter of challenge, then it will be appellate tribunal should consist of 5 members and from diverse background, one judicial, one technical, depending upon the dispute. And each institution should have, like I was thinking that we should have a tribunal of appellate tribunal judges should be 16, 17, 15. By rotation you can circulate and
like many other institutions have it across the world. Yes.
There it is not called appellate tribunal, there's a court of but the jurisdiction is the same.
Jurisdiction is the same.
Names won't matter, but so therefore one need to test it. One should not be apprehensive about it. It may come out to be bad. Maybe with the passage of time it gets fine-tuned by practices or by judgments. But I think the basic delay is in court, section 34. And some people say that it takes more than 10 years to decide objections. Even Delhi High Court, it says takes 5 years or so. Some the later one are being decided faster, but the old one which are in archives take a longer period.
Judge, I'll add to yours, sorry. And it's a very interesting position that I know of a case where an award is of 2012 and the section 34 still is in the same position as it was filed. We've forgotten.
This argument, in fact, has been used against India at various international
But it is not an
forums.
argument against India. It's also answering that the novel thought processes, like Justice Gupta mentioned, to say unique, provoked thought processes of appointing or establishing an arbitral council of India or having an arbitral appellate tribunal are great thought processes which should be pushed faster rather than have any apprehension, as he said, because they may bring about some systemic change. We also discussed about appointments, and Justice Gupta was very kind in the words that he used.
It always is.
But I know for a fact that the 11-6 jurisdiction with the Honorable High Court, subject to taking a peril of being under some contempt, is presently not functioning in the manner in which it is expected to function. Courts are overburdened with 11-6s which are pending over 3 to 4 or 5 years now.
And on that point, I want to ask you, sir, that the reality of our country is that our courts are overburdened, and that's the peculiar reality of India with which we have to deal and better it with time. But is there, like Delhi High Court has a commercial division, they have separated that. Is there a need to have, say, special benches at the Supreme Court or the designated courts which have actually the jurisdiction? You pointed out 3 of them in the country. Do they need to have special benches, specially trained judges who are equipped to deal with these matters, because they are highly technical matters and sometimes require a different kind of expertise to even deal with them?
No, it sounds good that there should be separate tribunals. But the difficulty is, like in criminal matters, crime against women or crime against children, special courts were created. How many cases are pending with them? You take a judicial officer from the mainstream and put them in the special court. There is another judgment to have special courts for MP, MLA's crime. It was difficult in Madhya Pradesh. I was in Madhya Pradesh. There was 150 cases in the entire state up against MP, MLAs, which were pending before the session courts. Then the question came, some cases are pending before the magistrate. What should we do? It should be put a separate magistrate. So we took a conscious decision. Those magistrates' cases will be also transferred to the session courts. At least one judicial officer we are able to spare. So, it's like a balloon. You press somewhere, the balloon will bulge somewhere else. So it's a problem. Creating a special court will not make a difference. We have to improve our entire judicial system to decide the cases efficiently, and this reasons to be recorded. It is becoming longish judgments. 100 pages. Award, setting aside of the award will also run into few, not 100, but few pages. So, in a case where you are not, maybe I may be criticized for that, to saying that it should not be that elaborate judgment, but don't discuss in a judgment like a evidence of the trial court.
The restraint that Kunal was talking about, which is such an important factor.
You must know your limits, outside limits.
Is it very difficult when you're on the bench to be mindful of that limits? I want to ask you this. Personally, I want to know from you, what goes on in a judge's mind?
One is conscious of this fact, that what jurisdiction you are exercising. Kunal has just said that 11-6 are pending, large number. I was designated by 2 successive chief justices to discharge the jurisdiction under 11-6. They were at one point in time 120 or 150 applications were pending. I had a bad reputation of quick decisions.
That's not a bad reputation.
So I finished all those cases. Because you need to take a quick call on this. if the arbitrator is not appointed, when the award will come, when the Section 34 will be decided. All these things are, are required to be done in more efficient manner.
2 points, Kunal, if you can talk about. One is that we cannot expect the arbitration ecosystem to be completely insulated from the problems that the Indian judicial system faces of various kinds that Justice Gupta spoke about. And second factor is about, we're proposing a new set of changes to the Arbitration Act. And these changes, do they really solve the problem of ecosystem? I'm sure it cannot be done in one stroke, but is it headed towards that direction, or they are too minuscule in nature, in your understanding?
They're very transformative in nature. They do solve some issues, but also make a great progress within the existing ecosystem. They're very transformative to address issues and very progressive to take this ecosystem far ahead than what we would have thought in the present regime. The problem again is going back to only one issue, is the mindset. Do we still want a great procedural law but not have an institutionalized arbitration? And do you want to have a great procedural law and have an ad hoc arbitration? With the procedural law being so robust and your system making available the institutions of great kind, why would we step back and not adopt some sort of certainty in implementation of that procedures by going through an institutional way of deciding your disputes? Faster, quicker, better, and certainly time is to be equated with cost. The lag that happens in the time value of money would change. The cost is far more higher than one would ever imagine.
Is our statutory framework right now promoting institutional arbitrations, or it should do it more often or more vociferously?
The statutory regime can never promote institutional arbitration. It gives a great level of recognition, and it has not been blindsided towards institutions from its inception. 11.6, as Justice Gupta said, recognized the existence of institutions. When we came with a time frame under 29A, the carve out, which was originally not crafted for the institutions to say that they can extend their own timeline, was carved out and given for the international commercial arbitrations and the international institutions who have their own regime of timeline. And to that extent, since parties have chosen those rules, party autonomy is honored and those rules are implemented within that strict framework and regime of timelines. So it is well recognized, a well understood system. But like Justice Gupta said, the hesitance at some point is far not understood to say that there is an application to appoint an arbitrator. You have a provision to say you can delegate it to the institution to do it, but we just don't land up doing it. It needs that mindset change. It needs the thought process to change. If the judiciary starts putting faith in the institutions to even a simple position of appointing an arbitrator, it will work. I will tell you, Delhi High Court has taken progressive steps in that front. 9 out of 10 11.6 orders which you will pull out on a day from the Honorable Delhi High Court, you will see that it is left to the Delhi International Arbitration Centre. Institution should appoint from its panel an arbitrator, and the matter is sent to arbitration. None of the cases that we as practitioners do emanating out of the jurisdiction within Delhi, we have chosen to keep it out of the DAC regime. Even if it is ad hoc, we will say, please allow us to do it under the aegis of DAC. An institution gained faith. Parallelly, new institutions have come up, like the IIAC, and that's what we need to do. An overburdened institution will obviously has its own problems to discharge the position, so you move and facilitate your disputes through another regime which is the IIAC or the MCIA, which are functioning very well within the nation.
One of the very important facets of international commercial arbitration is the fact that as economies became global, our disputes became transnational, boundaries are not as much important. Kunal is an international lawyer. There are various international lawyers who are interested to come in India. And this has been a hot topic of debate and discussion. Your thoughts on that, sir, and to what extent should foreign lawyers / firms be allowed to come in India?
I would say that Indian lawyers or Indian law firms should not be apprehensive of the foreign lawyers coming in India or taking their pie of work. I think with competition we'll grow better. The law firms and the advocates will work better. The best practices, whatever they have. No, if Indian lawyers are better, the foreigners will learn. Or the other way, the foreign lawyers are better, Indians will learn. I would appreciate a sport, the allowing of foreign lawyers in India. No, what is the difficulty of, they say, apprehensive of the bar, that the foreign lawyers will take away work, and that is, is a myopic view, according to me. We should welcome all and decide, take it up.
And so, in fact, that is one of the ways of creating that ecosystem, right? What you pointed out, to have the right kind of competition between lawyers so that the quality of work in India can go up.
No, the difficulty is because I am, one of lawyers shared his experience in respect of international arbitration where foreign lawyers were in India. When objection was raised that the Bar Council of India doesn't permit the foreign lawyers to appear. There was quite a debate and so on and so forth. But at the end of the hearing says next sitting will be in Singapore. So what India has gained, what Indian lawyers have gained, nothing. We have lost everything. No, I think Bar is a big pressure group. In no other country, so many lawyers meet every day.
Kunal, your thoughts on the matter?
Judge,
are you scared of the competition coming in India?
I am certainly not scared at all, and I completely support the thought of gradually opening.
Okay, it's gradual, right?
Yeah, our ecosystem to the foreign lawyers.
Yeah.
The concerns that I have presently are upsetting the pre-existing gradual opened system that we had. We had a judicially framed fly-in, fly-out regime which was under a judicial order, which was existent and which was playing a great role in building this ecosystem, at least as far as arbitrations is concerned. Since we are discussing only the portions of arbitration, I'm sticking to that. But if you had asked me a question sans arbitration, I would have still said that I am not scared.
Okay.
Ours is the only profession where we can coexist.
Okay.
And when we coexist, we have a huge learning curve with each other. You can only be bigger and better if you go together. An open hand is a slap, a closed hand is a fist and a punch. Nature has taught us these lessons. They are part of our daily system. Correct? We can get together with a gradual way of opening, protecting the system that exists in our nation, which is demographically, all of us know, a very, very different way of functioning in terms of the legal system, and ensuring that at least all other avenues where possibly you can collaborate with each other, you are working in tandem, and the system allows that.
Yeah.
The system today is probably on one hand saying we want to open, we want to allow the foreign lawyers to come, but I will put down that many number of rules which actually makes it just impossible for them to come even if there was a remote chance.
And what's happening is, as Justice Gupta pointed out, the work is going outside.
Yes.
The work.
You start looking at alternative jurisdictions because the faith system within the space of lawyers globally or the litigants globally would drop immediately.
Yeah, I could carry on this conversation for hours, but I know you both have limited time. Justice Gupta, you're leading this premier institution in India, and I'm sure in the times to come, this will be one of the leading ones, which will set up and make institutional arbitration one of the key ways of doing arbitration in India. But what have been your lessons? That's one point I'd like you to speak on. And the second one is about the proposed changes to the Arbitration Act. How soon you think they should become a reality? Is it time that they should immediately be put into effect? These 2 points, sir.
Taking your second question first, I think the amendment should be carried out at the earliest, because all these amendments would be a step forward in developing India as the seat of arbitration. The first question is very difficult to answer. I will say that I had a good time, cooperation from all, but much more could be done, which I was not able to do because of multiple factors, not within my control, but intervening factors which come up. But let's hope for the best.
Let's hope, sir. And your contribution does count, sir. Kunal, your thoughts on both these facets?
Taking the first question then first, is the hope as far as making any institution successful is not a hope against hope. This is an institution which came about with legislative intent, with a absolute clear thought process of what is expected out of this institution to grow into and deliver. The problem that I see is that it has now become an act of ticking a checkbox. Does India have an institution of its own? Yes. Who gave birth to that institution? Who conceptualized the institution? Of course, none other than the government of India. 2 boxes well ticked. 3. Is this institution the focal point of all stakeholders for it to be the catalyst to make India the great arbitration ecosystem or a great arbitral seat? The answer is we are fragmented. We need to gather and align our focus on what is the power and might of a successful international arbitral institution, particularly because we've got leading minds and great jurists like Justice Gupta who have now sown the seed of making it a successful institution. The seed is there, and Justice Gupta is humble, so obviously he says that he could just do that much, but he doesn't know the magnanimity of that seed and what he has sown. But my fear is that we move on from here. The focus needs to be to nurture this seed, to grow this plant and make it into that banyan tree that will engulf within it every single aspect that is required for successfully resolving disputes through the medium of arbitration.
So I asked a couple of my younger lawyer friends that I'm meeting the 2 stalwarts today, and what is the question that I should ask? And the final question I want to end with is that what is your advice to young lawyers who want to step into the world of commercial litigation, commercial arbitration? How should the AI-enabled Gen Z really prepare themselves for the times to come? Justice Gupta, do you have hopes, high hopes from them?
No, I have high hope from the younger generation. They are bright, intelligent, hardworking. They need little hand-holding, but they can do wonders. I see for myself, what was my preparation in 1980 when I joined profession. And then my son, who is joined in 2012, the way he works and way I used to work is a miles different.
Yeah.
So I have a hope, a little hand holding, little direction would do wonders to them. One thing is there is no shortcut, hard work, and hard work.
Lots of reading and lots of writing. There's no shortcut. Kunal, your
Absolutely.
thoughts?
So, next gen, in my mind, is pre-educated from the mother's womb. They're very, very smart.
Yeah.
The only factor that they must not forget is that we are students for life in this profession, and that fire to learn within the belly can never be doused by any medium of success, be it a short-term success or a long-term success. That fire within you to be the best and consistent always must be maintained in the next generation. You also touched upon a very, very important word, which is AI.
AI enabled generation.
Yes, it is an AI enabled generation, as long as they understand that artificial intelligence can never substitute the next gen intelligence. Their own intelligence is far supreme than what the gadget through its AI is going to do. AI is an aid. AI is the need of the hour, but as an aid and a tool and not a substitute. I get asked several times a question, and I repeat this all the time, saying, do you see people in your offices being substituted because of AI? My answer is very simple. I can never substitute human intelligence with artificial intelligence, for sure. But I will substitute those human beings who do not know how to use AI.
True, very true. But Justice Hemant Gupta, Mr. Kunal Vajani, this has been a fantastic conversation. Thank you so much for your time. And maybe next time we'll talk at length about AI and how it has changed the world. Thank you so much.
Thank you very much.
Thank you. Thank you very much. So nice.